Broadcasting live from the Business RadioX studios in Phoenix, Arizona, it's time for Phoenix Business Radio, spotlighting the city's best businesses and the people who lead them.
Thanks for tuning in to Legitimate on Phoenix Business Radio X. I'm your host, Rochelle Polton. I'm a consumer rights attorney at AZCLG, here to bring you the full perspective on issues that I handle every day. And welcome to Series 2, The World of Debt. And today's topic is landlord-tenant legal issues. My firm represents a lot of people on the tenant side, specifically people who have been evicted or receive huge bills for post-move-out damages. But today, we also want to explore landlord-tenant law from the landlord side. So basically the do's and don'ts of owning investment residential real estate. So with us, we have three awesome guests to give us their legitimate perspectives. And we have Irene Ploski, owner of Independence Insurance Group, PLLC, which helps people with their personal and commercial insurance needs, including yours truly. And we also have with us Nick Stratton, owner of Bullseye Property Management, LLC, a full-service property management company for Arizona residential real estate. And last but certainly not least, Andrew Holl, Dr. Evictor himself, partner at Holl and Holliday, author, educator, keynote speaker, and practically a legal icon in Arizona. So welcome all of you, and thank you for joining us. And please tell our listeners more about you and your businesses. Ladies first, Irene.
Hi, it's great to be here. Well, my name's Irene Ploski. I have been in the insurance industry for 16 years. I have owned my own agency since 2009. And we are an insurance brokerage agency. So that means we represent several different insurance companies to find the right combination of coverage and price for each of our clients.
Awesome. Awesome. You don't look old enough to be doing this for 16 years.
Well, thank you.
And Nick, your turn.
Yes, my name's Nick Stratton. I got licensed in real estate back in 2005. Tried sales for a little bit and then went and worked for a big property management company. Started out as a leasing agent and worked my way up doing pretty much every facet of property management, from inspections to being a property manager to signing up new owners, and then worked for a large company overseeing about 2,000 doors across 4 states, and decided to scale it back a little bit and open up my own business back at the end of 2014, beginning of 2015, and here we are today.
Awesome. And you have a fabulous website.
Thank you.
I like your story. It's awesome. All right, and Andrew, please.
I graduated from the University of Iowa, came to Arizona, and have been practicing law for almost 40 years at this point. Our firm only represents landlords and property management companies. And my 2 partners, Kevin and Denise Holliday, have in excess of 25 years each. And we do a lot of training and, again, just specialize in handling landlords' issues with tenants.
Love it. So as you can see or hear, we have quite the panel for today's topic, landlord-tenant law. But first, let's do some background. So today we're covering residential landlord-tenant issues. Commercial real estate is a totally different animal. The Arizona rental market is huge. There are literally thousands of single-family residents available for rent in the Valley of the Sun. And there are also many laws that govern this topic, including the Arizona Landlord-Tenant Act, contract law, the restatement of property, case law, and of course, every city has its own ordinances. And bonus, the law changes to accommodate new problems like bed bugs and, of course, domestic violence. And coming soon is regulation on short-term vacation rentals. So if you think you know the rules, please be sure to check with a professional. Key takeaway today. Also, there's numerous agencies involved, like the Arizona Department of Housing, Arizona Department of Real Estate, Arizona Department of Insurance, Arizona Department of Revenue, and of course the County Assessor and Recorder's Office, and it just goes on and on and on. Regulation of real estate in Arizona is quite extensive, so that's why they call it a legal practice. You are constantly practicing, and that's why you need professionals to make sure that you are getting the right answers. And do not forget, we are not giving you legal advice. This is just a friendly conversation about a fun topic. So now to our guests. Please tell our listeners about your role in this industry and what you do or why people should use you.
So in my case, I provide advice to both tenants and landlords. In this case, for landlords, how to protect their assets. In many instances, landlords assume certain things that their policy may not cover. So it's very important to have a good broker and a good relationship with that broker to address the changing needs of the landlord, as well as the laws and regulations. So we focus on strong relationships with all of our clients. And so it's very important because of that relationship that we continuously have a conversation with our clients to make sure that their needs are covered.
Awesome. And Nick, your turn.
It's me. So my role in my company is I'm the owner operator. So basically I oversee it all in a property manager's role. And that includes for a landlord, when they hire me to secure a tenant, find a qualified tenant to rent their property, whether it's a single family home or a multifamily unit. Also to oversee the day-to-day operations, which includes rent collection, overseeing of maintenance and contractors. And then, of course, if there are any legal issues, I get the legal team involved. I actually use Andy's office quite extensively, so they're great. And then, of course, move-outs and marketing. And then the normal accounting things that go along with that, monthly statements to owners, 1099s at the end of the year. So those are basically the main structure of what I do and oversee for each of the property owners that I represent.
Awesome. And Andrew?
Primarily, we're, I guess, a litigation-oriented law office. Evictions take up probably 80% of our practice. And so we may have big apartment complexes that have multiple evictions they need done, down to the single-family owner that has maybe one rental house. And we do a lot of training. We offer free training to any of our clients. Once a month, we do landlord-tenant law. The next month, we'll do fair housing, and then just alternate those. We do a lot of defense work on disputes over security deposits. That either they didn't get their deposit or they didn't get what they felt was a fair amount. And there are some procedures they can follow under the Small Claims Act to pursue those claims. We get a lot of our clients that more do defense work from claims tenants bring. But
awesome. So hear that, purely landlord side. Mm-hmm. So we're going to get the full perspective here today. So in your opinion, what are the top 3 things that someone should know before they start renting real estate? And we'll start with you, Nick.
Oh, starting with me. Okay. Threw me off a little bit. Top 3 things from an investor perspective, there's 2 types of landlords in my mind. There's an investor who will be purchasing perhaps a bulk assets, and then there's the one owner that decides to move out of state and keep their home as a rental. And I think for both of them, the thing that both should understand is look at it as an investment property and not as a property that one used to live in or to be attached to it. It makes it easier to make business decisions when it comes to property management. And that makes things a lot easier. The second thing I would say that is to look at all the costs involved as well as the potential costs from an investment property, which includes there is maintenance that happens. I call a house a living organism. Just like our bodies, when we get older, we have bumps and bruises. Houses, when they get even a year old, things happen, things break, things malfunction. So just be prepared for any maintenance costs. And then the third thing I would say for them to know is to be prepared, or I guess to have, in mind what their long-term strategy is when they go into it. So for some, if they're moving out of state, they say, well, I want to hold on to it because I may want to move back, and that's one strategy. Another one may say we want cash flow. So understanding your strategy will help you determine what your best course of action is. And we'll be talking about it later. I saw on the outline as far as Airbnbs, for example. But, if someone wants to come to their home, 3-4 months out of the year, then a long-term lease option is probably not going to work for them. And they're going to want to do something where it's more of a short-term option.
Awesome. What about you, Irene?
Well, I'm going to say consult with a tax professional and plan for any immediate and long-term tax liabilities. Create an LLC, I think, is very important because it adds an additional layer of protection for the landlord, and also to discuss with that professional how to write off expenses the best. Also, have a discussion with your insurance agent on how liability applies to a landlord, because in the example that Nick gave, when somebody lives on a residence and then they move out, that insurance policy has to change to address the needs of a landlord, because a homeowner's policy addresses the needs of the owner of the property that resides there. So that is a very common mistake that we see, and it's very important to address. Also, consult with an attorney and have a procedure in place from the rental application process, running background checks, have a solid lease agreement, and one that protects the landlord and the property, and that addresses how issues will be resolved.
All solid answers. All right, lawyer time. What would you say, Andrew?
Well, first thing I think is to get everything in writing. You don't want verbal agreements. So, and that comes along with just knowing the laws. In our website at our office, I think we have probably maybe 60 things, a landlord checklist, and just make sure you have a good solid lease agreement. Then I guess the other thing would be to walk the property with the prospective tenant, so you can get the condition down at move in and compare it at move out in case there's any claim for damages, property damages.
Solid. Those are very, very great tips. So what are the most common problems that your clients experience, and what do you do to help them?
So for me, as I mentioned, is when people assume that their old policy will cover their new needs, and that's usually never the case. So making assumptions is, to me, always the wrong approach. It's a conversation with an insurance agent that can solve a lot of issues. Being proactive, to me, is the way to go versus learning once a claim has already occurred. That's not the right way to learn. So that is the main thing that I see, is that people assume that because they have a policy, it'll cover the property, and there is much more to protect. There is the liability. Again, the liability of the landlord is completely different than the liability of a homeowner. And it's seen differently. Also, the insurance policy has to cover for the landlord the loss of rent. So that means that if there is any type of loss in the property that is being rented that makes it inhabitable, and the tenant cannot live there, the landlord is going to be losing that income. So with the right policy, that is something that can be claimed as part of the overall claim process.
Wow. Pretty cool. Nick?
I think some of the things that when I encounter owners, whether they've been using me for a while or they're brand new owners, sometimes they don't know what they don't know. Being able to have a resource like Andy, or going to continuing education class, they often will ask me to do certain things that they don't think about because they say they own the property. So, for example, different notices or going to inspect the property. And so I educate them a lot on what I can and can't do and what's in their best interest. And so I'm able to meet their needs. For example, doing inspections in the timely manner, or getting a condition of report of the property. Also handling different situations with the tenants, different legal things that may come up regarding rent collection, or different maintenance things, and working with them to create a solution that works for all parties, because there's the legal aspect of property management and understanding the law, but then in the practical aspect of it is figuring out how, because at the end of the day, it's still working with people. And the biggest thing is, even though they may be right on a legal perspective, it's better to kind of smooth things over, and that's kind of what my job is more of a mediator sometimes, and that's how I help them solve their problems to keep them happy, keep them protected, because I do represent the landlord, and at the same time I do have to be fair and honest with the tenants, and so to make that kind of smooth and create a good situation for everyone.
Yeah, you don't always need a hammer to bat a fly.
No.
And Andrew, what would you say?
Well, I think we do, like I said, the bulk of our practice is evictions. But when an owner comes to us, there may be multiple types of notices they could serve. So we have to determine which notice is appropriate. Non-payment of rent's pretty clear. Whether something's grounds for an immediate eviction, which is like criminal activity on the property, or non-compliance, unauthorized occupants or unauthorized pets are brought into the property, then we instruct the landlord on what type of notice to give, how to serve it. And then other than that, as I mentioned, we do a lot of defense work. So we get a lot of tenants that are filing small claims cases for their security deposits, and the landlords want to use our office, so we are able to transfer the matter out, get it into the regular justice court, and go from there, and give them their options depending on the issues that are presented.
Yeah, because every case is, I think, unique. So I don't think I've ever run across a tenant on my end that had the exact same problem as another tenant. I imagine that's probably the same for landlords.
Yeah, you think you've seen it all, and something new comes up every day.
Yes, it's fascinating. Fascinating stuff. So let's see. Story time. Tell us a story about a time you really helped somebody. No names. Keep it, no personal information, all that fun stuff. Who wants to go first?
I'll go. I've got a couple that come to my mind. One is with a tenant that moved in just probably 3 weeks ago. And this is a small thing, but he texted me at 6:30 in the morning. He said, "Hey, I'm on my way to work and I locked myself out of my place." I try to help where I can. And I said, well, I'm going to be passing, by this place. And if you want to meet me, I can, give you an extra copy of the key. And so I met him at Chipotle at noon because I had a 15-minute window before I had to go to my next appointment. And he met me and got the key, and worked out well for him. Another instance, I had an owner that needed me to stop by a property on a weekend for something. It was really last minute. Kind of had to do with some maintenance that was going on, and so I went out there and did it myself. And so that's kind of part of the things I do to help my owners and to provide more of a quality service to owners and tenants. So
awesome. Irene?
I recently experienced an interesting case in which my client was purchasing a property as a rental, but in fact, it was going to be their secondary residence. So that created a lot of insurance issues because the lender wanted to see a rental property policy, a landlord policy in place in order for them to close their deal. But the property was going to be used as a secondary residence where the owner was going to live in. So that was a bit of a headache going back and forth with the lender because the underwriters need it a certain way, so it has to be done that way. The policy has to be exactly how they require it. But from an insurance standpoint, that is not addressing the true needs of the client, of the property owner. So we set up two policies in place. We set up a policy so they could close their loan, and we set up the right policy in place, which was a homeowner's insurance policy that truly met the needs of this client. And they had a small liability claim, which wouldn't have been covered had we had insured the property as a rental. So catching those things is one of the things that we do by having conversations with our clients. We try to be very proactive and address things before they happen. So
it's just pretty handy to have a professional to call. Like in the case where you're the landlord as an individual, they're just calling you at 11 o'clock in the morning. Hey, can I have a spare key? And you probably can't do that if you work a full-time job and you don't do this for a living. And for insurance purposes, where do you even begin to get that information from Google? So what about you, Andrew? What's the story that you've got?
Well, I have, I can't think of one particular, but there's one that's reoccurring. And that's, as you know, we do our evictions. And a lot of the tenants don't understand the process. And it's very difficult because they're possibly losing their home. They don't know where they're going to go. and you want to treat them with dignity. And generally, I will take the people out in the hallway and talk to them, try and be as kind as I can, explaining they're not going to come and lock you out today. You still have a week to get it resolved with the property owner, perhaps get a partial payment agreement or something so you can keep the property. And I've had a lot of nice tenants thank me for being a gentleman as far as their case went.
That's awesome. I think it's the eviction side. We usually find out about evictions years later because people don't attend those forcible detainer hearings. They don't realize how fast that process is, or the fact that it's a judgment. They tend to just not really understand that at all. So it's always nice when you hear an attorney on the other side who takes the time to tell them, like, hey, this is what's going on, and this is how you can solve your problem. Pay your rent. Usually the solution. So we represent tenants a lot, and I want to chat about the issues that we get regarding bills and their legitimacy. So the number one issue that I see is pets. So you deal with like carpet replacement, the deep cleaning, poop removal, all of the fun stuff regarding pets. So can you guys speak a little bit about what's out there? What really are the rights of landlords, and what's going on your end? What do you see?
Well, from an insurance standpoint, that is something that really the insurance policy does not address. Damage is covered when the tenant causes accidental damage to the property. But of course, it's subject to the policy deductible. So that is definitely not something that would make sense to
file a claim over.
Mm-hmm. Yeah. So yeah, I will defer to the other two guests to address this in their specialties a lot better than I can.
I'll explain a little bit more about my process, and it does relate to pets or carpet replacement. One thing to keep in mind that sometimes landlords forget, or property owners, is that everything has a shelf life or a lifespan. So carpet that is installed, depending on the grade, may last 5 years, and it may last a less or a little bit longer. And obviously it's going to depend on the tenant. So there's some of that to take into consideration. It's pretty cut and dry. If I installed carpet this year and the tenant moves out and it's pretty hammered and destroyed, I could charge the tenant for most of that. If the carpet's been in there 10 years, I probably couldn't charge for any of that, depending on what the condition. So alluding to what Andy talked about earlier, that's why move-in condition report's so important, and photographs, videos where appropriate. And so, yeah, you can charge. It really comes down to documentation. So again, deep cleaning, pet urine stains, things of that nature. If it was documented that it was not like that when they moved in and they moved out, then yeah, that's something that can be charged. And having a reputable or a licensed contractor, I use a company very frequently that provides me itemized bids, which makes it very easy when it comes to deducting for tenant deposits, which is usually the biggest dispute. If a tenant ever comes back and asks me after the fact, I say, well, let's have a conversation and go from there. And usually that helps things go a lot better.
Agreed.
Well, I think from our perspective, there's two types of pets. There's the assistive animal, fair housing issues on one side, and then there's the regular pet that a tenant would have. So we want to determine at the beginning of the lease, if they have an assistive animal, you can't charge rent on, you can't charge a deposit. They are responsible for the damages that the pet does, if anything. But we want to make that determination at the beginning, and if they have an assistive animal, the tenants do need to let us know so that we can, again, not charge them those things. Otherwise, it's the regular house or pet that you take. And with carpet damage, there is an Arizona Supreme Court case that says it's really up to the discretion of the trial judge based on the age of the carpet at the beginning of the lease, the length of time, what's normal wear and tear. Did they blacklight the carpet to determine if there's pet urine damage? And those are kind of the things we look at. We do see with pets also, unfortunately, occasionally a dog bite case, and the tenant is responsible for the actions of their dog under Arizona law. So,
Denise in your office always tells the story of the owner who cut out a section of the carpet that was urinated and kept it for the court case, and the judge asked her to open it up and had to clear the courtroom. So
Ooh.
that was one way. The judge, I think she always says that he said the overwhelming evidence of how bad it was.
And if I could just add real quick to what Andrew was saying about the dog bites, so insurance does address that. And that's why it is so important for landlords to require renters insurance, because in that case, that is something that would be addressed under the renters insurance policy. So the tenant's policy will be the primary coverage, which adds an additional layer of protection for the landlord. So then if needed, then the landlord's policy can come in second place. But it is extremely important for landlords to require renters insurance because it's in their best interest, and it's only an additional layer of protection for them.
Yes, and you also help people with renters insurance, and it is surprisingly affordable.
Extremely inexpensive. And a lot of tenants say, well, I don't have that many things, so I don't need renters insurance. Wrong. Renters insurance covers a whole lot more than just your personal belongings. It covers, again, your liability, so in case of a dog bite. And it covers if there's any kind of damage in the property that you rent and you cannot live there. It covers those additional living expenses that you're going to incur. So living in a hotel or another place that you're going to have to rent, additional transportation, eating out. And it doesn't even necessarily have to be damage that you cause. It can be your neighbor caused the damage and it affected your own unit. So now you can't live there. Well, you can claim that under your renter's insurance policy and save yourself the headache and the expense for a very, very affordable premium.
Yes.
I had some tenants that their house caught fire and they did not have renter's insurance. This was a long time ago. It was not ones that I put into the property. And they had a dog and they lost all their possessions. It was really sad, and they had nothing to fall back on in that situation. So,
because a lot of people don't think that they have a lot until it's lost, unfortunately.
And most of our clients now are making it mandatory that the tenants get renter's insurance as part of their lease agreement. And as an owner, if you have an incident with a pet biting somebody and you don't take steps to address it or remove it, and it happens again, then the owner may become liable for their negligence.
Yeah, so pets are a landmine of legal issues, apparently. So tenants that move out a few days after their lease is up, there's a big debate over how much rent do they actually have to pay. So what I get is someone says, well, my lease ended on the 30th and I moved out on the 2nd, so I only owe 2 days of rent. Either of you have any clarification on that point?
I'll defer to Andy on this one.
Well, I guess it depends on the lease. If the lease is expired and the tenant's given appropriate notice we're not going to renew, maybe then you'd charge them 2 days of rent. But some of the leases we see, they'll charge 2 months' rent as an early termination fee, and then another month's rent for failure to give a 30-day notice. And we have to advise them on, if you get it re-rented within a week, you're not entitled to all these additional fees. And some of the leases, they'll put in there that they forfeit their deposit, which you can't do under Arizona law. You have to itemize it and give the tenant credit for it. So,
Andy, is it something that you see that can be addressed with an upfront conversation with the landlord? Hey, I'm going to need a little more time to move out. Or is it very strict if it passes the...
Most of our clients have been very flexible under those circumstances.
I literally just did that this last week. I had a tenant that gave notice to be out. I scheduled a time to come out, and then he emailed me that morning, said, hey, I need another week. And if it's something that continue to drag out, there are notices and things that one can do if they're just squatting, so to speak. But I knew he was getting stuff out, so I had a conversation with the homeowner and said, hey, so essentially we just charged him for every single day that he was in and not beyond that. And some of it came out of his deposit. So that's how we handled that.
Yeah, a problem comes up when you have a new tenant that wants to move into the property and the old tenant has not given their termination notice. And so you've got new people wanting to move in, the prior tenant's still in the rental house. And really your only remedy under those circumstances is to file what's called a holdover eviction. The judge can assess them 2 months of rent plus an additional month's rent for not moving when they should have. So we use that as an encouragement that the tenants will move out when they should and give them that information ahead of time.
Awesome. So the key is if you're planning on staying longer as a tenant, communicate and with your landlord. And as a landlord, they're probably going to be reasonable. Fair?
I would agree.
We would hope so.
Yeah.
I won't speak for all landlords out there.
So post-move out damages. People forget this part when they move out of a property, whether they were evicted or they just simply moved out. Can you guys speak to that point a little bit more?
Well, the Arizona Landlord Tenant Act and hopefully the lease does spell out that the tenant can be present at a move-out inspection. They just have to request that, and then the landlord will tell them when it's going to take place. So we encourage, make sure if you do a move-out inspection, try and do it with the tenant so you can both see the charges that may or may not be assessed. And a lot of it just depends, again, on how long the tenant was in there, normal wear and tear, and
those kinds of issues.
Yeah.
Just normal. Because when we see post-move out damages, we'll see repayment of concessions, occasionally the early termination fee, the failure to give notice fee, and those can add up pretty quick. You can get to $3,000, $4,000 pretty fast on that alone. But then you end up with extra cleaning fees. They forgot to clean out the refrigerator, forgot to clean the baseboards, didn't get the carpet cleaned. So we see a litany of charges that happen post-move out that sometimes people just don't know about. I think one of the key points is sometimes tenants won't give a forwarding address when they move. So if they're expecting a security deposit or an itemized statement, they never get it because it got sent to the address that they used to live at. How do you address that problem, Nick?
Most of the time, I don't have that issue except for, I would say, evictions. I usually don't get a forwarding address. I ask for it, but most of the time they don't really want to communicate with me. I've dealt with a lot of evictions over the years. I do my best to hedge against that because it's not something great for the landlord. But for the most part, I do get forwarding addresses. If I think there's going to be an issue where I don't have it, I have to protect myself and the landlord. So I will send it. If there is any type left over, what we've kind of been encouraged to do is to send, a copy of all the charges or the deposit disposition form, and I'll send that via certified mail, so I have proof that I sent it. And then the actual check, I'll send regular mail to whatever last address that I have on file. So that way it doesn't get held up in the mail, sending it certified for the actual check.
Yeah, because those you end up at the post office for 2 months and then you get it back.
Yeah.
Hopefully it just gets forward. Any tips on that issue, Andrew?
Well, they did change the Landlord Tenant Act about a year ago, and normally the landlord has 14 business days to either refund or itemize the deposit after the lease ends, keys have been returned, and the tenant makes a demand. And if the landlord may be subject to treble damages if they don't properly itemize the deposit. But the law has now changed that if the tenant doesn't question or challenge the deductions within 60 days after the landlord mails them their copy of their itemization, then the charges become correct and can't be challenged.
So they become per se valid?
Yes.
Yikes. That is a fast turnaround time. I mean, I'm a consumer rights attorney, so obviously I have an issue with that one. But that is the law. That's the state of affairs. So let's talk law. Repairs. What is required? And can you explain this self-help thing to some of our tenants?
Yeah, there's a section under the Landlord-Tenant Act for remedies by a tenant. One is called a non-compliance notice. They can give a landlord a list of things that they believe are the landlord's responsibilities. And if he doesn't make those repairs, they can terminate the lease and move out as one option. The other option they have is they can give the landlord notice to fix X amount of things. And if the landlord doesn't do that within 10 days, the tenant will hire their own licensed and bonded contractor, get a lien waiver from the contractor that he's not going to put a lien on the property for the work he did. The tenants pay the contractor, and then they can deduct half a month's rent or $300, whichever is greater, off their next month's rent.
So do these notices, does it count if they just call and leave a voicemail?
Legally not. Really, as the law stands today, they must be in writing and physically handed to somebody or sent certified or regular mail. And if they're sent certified mail, they're deemed received 5 days after mail.
What about text and email?
If it's in the lease and the parties have agreed to that, I think sometime fairly soon they'll change the Landlord-Tenant Act and allow that. So now if you want to communicate by email, and then you just make sure your lease has that the tenant also agrees to acknowledge receipt of the email.
Perfect. Thank you. Anything to add, Nick?
Not really much to add. It's the thing that I might bring up is as far as what's an emergency and what's not an emergency.
Yes.
So fire, safety. In classes I attend where Denise is teaching, or I don't think I've been to one of your classes in a while. They'll say fire, flood, or blood, just kind of as a. But HVAC failure or heat failure, depending on the time of month.
So July, no AC.
July AC, that would be considered an emergency. Fire safety issue, complete plumbing backup or a flood, things of that nature, considered an emergency. If the window's not closing, just right, or latching or whatnot, that wouldn't be considered an emergency. Still needs to act appropriately. So during those situations, the landlord is obligated to act quicker, basically to act within 48 hours. Does that make sure I get that right?
Yeah, if it's something more of an emergency, yeah.
So what about a holiday weekend?
40. I mean, if it's an emergency, it's an emergency. So, I mean, it's day or night. I mean, if it was a flood, I mean, you don't plan an emergency. So you just have things set up in place. And most property management companies have an after hours line to handle things of that nature. And there are contractors that do go out on holidays for those types of things. It costs a little bit more, of course, and the landlord might not be thrilled to pay the extra costs, but to protect them legally, it's important to have those systems and processes in place.
Agreed.
I would just like to tag along that with the flood. Flood is specifically excluded from the insurance policy. So in order for there to be coverage for flood, the landlord has to have flood insurance. And if the property is not in a flood zone, it is very inexpensive. So it's worth looking into, as that is a specific policy exclusion.
So a plumbing flood would count as a flood?
No. That's
Okay.
considered. Well, if it's water backup, there's a difference. Water backup is usually limited to a certain amount named on the policy unless it's changed. If there is accidental discharge of a pipe, for example, that's different. So if the water seeps from above, that's water damage. If the water comes from the ground up, that's flood.
Nice distinction. Okay.
I should clarify, yeah, when I'm speaking of flood, usually, especially in Arizona, we're talking about a pipe bursting in the wall and water coming out the front door.
Yes. And those are restoration companies that you're calling at that point.
Exactly.
Yes. So should a tenant ever call a restoration company?
The tenant should always call the landlord to let them know what's going on, because if they call out their own company and, the leases spell this out, and that's where a homeowner or a landlord will want to take a look at what's in their lease, requiring the tenants for any type of repairs to contact them, because you have no idea, if someone's insured, if they have the proper licenses to do that kind of work, and that can create a hold the litany of problems if they're calling anyone and everyone to come fix things without notifying the landlord.
Yes, I have seen that happen firsthand a few times, and I usually have to give the tenant the bad news of you should have called the landlord because you're the one who signed that contract. Never ideal.
And there is a section in the Landlord-Tenant Act that directly addresses failure to supply essential services, which heat, air conditioning are considered. And it does say that if the landlord deliberately or negligently fails to provide these services, then the tenant can either sue for damages, go out and get the rental, like a AC unit, and deduct the cost of that, or go to a hotel or a motel. But they've got to give the landlord notice first. And then most of our clients, we encourage them, give the tenant the days off that they were without the AC. But technically, if they didn't want to do that and they couldn't, and if the landlord got, contacted, let's say, an AC company, and it took them 4 or 5 days to get out there, get parts or whatever, that would not be considered negligent or deliberate on the part of the landlord.
Good to know. Very fascinating, because I think from the tenant side, they get really frustrated because it's July, it's hot, it's been longer than 48 hours, and the issue still isn't fixed. So if there are landlords waiting on a repair company to actually come out and get the parts, then you need to just kind of suffer through it.
Well, we still encourage our clients, hey, it's middle of July, they don't have AC for 3 or 4 days, give them something for that. It's good PR with your tenants.
No, I dealt
Agreed.
with this over the summer. Home warranty company. Those are things that they're great because they cover a lot of things and they can be tricky. So ordering a part for an air conditioning in the middle of July, getting them out there, the tenant was basically without. There were 2 ACs in the home, but was without one of them for about 2-3 weeks. So they got a hefty credit, is what we offered to, the landlord offered to either put them in a hotel. They said, no, we'd rather take the credit. So we ended up crediting those days. I think actually credited 125% of the daily rate for the inconvenience. They've been a great tenant. So it's just, sometimes it's one of those things where when you're dealing with something like a home warranty company where it can get dragged out even longer.
So communication again.
Absolutely.
So what about rental housing discrimination laws? Sometimes I hear about a tenant or a new landlord, they bought a house and they don't want any of those pesky kids. Can you guys speak on that a little bit?
Well, the insurance policy for the landlord will always, the insurance company has a duty to defend. So even though the allegation may not be true or may even be fraudulent, the insurance company will pay for the cost of defense in case of an allegation. So that's step one. And then depending on the policy, depending on the insurance company that the landlord is insured through, that is something that may be covered.
Interesting.
From a property management perspective, it's, it's having that conversation with the owner up front and educating them on what I'm able to do, what I'm not able to do. And, if the owner becomes adamant about certain questions like that or wanting certain things, then at that point I have basically an opportunity to make a business decision. Is the liability worth that? And, most owners don't do that once they're explained the fair housing laws, but there are some that are adamant.
Denise in our office handles all of our fair housing, so I'm not quite up to speed on all of it. But there's 7 categories, and the golden rule is treat everybody the same as far as the application process, conditions of the lease agreement, and I can share one kind of crazy story if you
Please.
Want to give me a minute.
Yes.
Tenant's out walking her dog in the apartment complex, and elderly lady gets charged by a pit bull, and she calls the manager, they follow the pit bull to this other tenant's house, unauthorized pet. It was in their tenant's folder, they had a picture of the dog, which was a Chihuahua. that had somehow morphed into a pit bull.
Wow.
And so they served the tenant a notice to get rid of the dog, and the tenant said, if you get rid of the dog, I'll shoot, or try and get rid of the dog, I'll kill whoever does that. So we served the immediate eviction notice, got to court. He hands us his bankruptcy filings, and under bankruptcy court, you can't take any action until you get permission from the bankruptcy judge, which usually takes a month or longer.
Yeah.
And if you violate the automatic stay in bankruptcy court, it's a $10,000 fine. So we tried to settle it with the Attorney General's office. They just wanted the person to be paid. Got the stay order lifted, showed up in court, and the tenant now had a 15-year-old son that was a member of the gang going around the complex threatening people that if you come to court and testify against my dad, it'll be the last breath you ever take.
Ooh, witness tampering.
So we had, I think it was 20 of the residents come to the court to testify about the dog. The judge ruled in our favor, and the tenants filed a fair housing complaint, got a court order in place keeping them in the property while the case was pending.
Wow.
And 8 months later, the owner paid him $125,000 to drop the fair housing complaint because they were a minority. They found out the gang kid had attention deficit disability to a small amount, so he was handicapped. And then they went back 7 years on the owner's property and found that 5 years prior they had evicted tenants for doing similar things, but gave them a week to move instead of the 12 to 24 hours because the parents had brought in proof that they'd moved the kids out of the state. So now they were alleging that along as differential treatment. And he had paid $80,000 in legal fees to that point, and the case was still a year and a half away from going to a jury trial.
Wow.
And so he just caved in and paid.
Yeah, sometimes those principal arguments are not worth it.
It is so important to follow the same process, the same procedure with everybody, every time. So
clearly. Could cost you money. That is a crazy story.
Yeah.
I don't know how I feel about that one. That's weird. There's a lot of ups and downs on that.
There was. Yeah.
So with the eviction, Andrew, can you explain what the process is and how fast it is in Arizona?
Yeah, the first step is the notice. The landlord has to serve the appropriate notice. Is it for 5-day non-payment of rent or some kind of non-compliance notice? Then the paperwork gets filed, and a process server has to serve it upon the tenants, and they can do that by posting the court notice on the door and sending it certified mail. And then you get a court date set up, which is usually about a week after the filing. Most of the judges try and get the thing resolved at the first appearance, but if not, then they'll set it over for trial, which is usually just 2 or 3 days later. And if the tenant is found guilty of forcible detainer, probably should say responsible. Guilty is kind of an old legal argument, but then they get 5 days to move unless it's been what we call an immediate, which is criminal activity, threats, property damage, the real serious things that go on, drugs, that type of thing. And so the normal tenant would get 5 days to move. That's 5 calendar days. And then if they don't move, a constable can be ordered, and they usually take 2 to 4 days to come out and change locks and make the tenant vacate and leaving there. If they leave their property behind, then they've got to inventory it and hold it for 14 days before the tenant, and the tenant has to pay reasonable storage fees to get the property.
So within a month, essentially, is the whole process.
Pretty much, yeah, close to 3 weeks, I would say.
Yeah, because I think a lot of times when we get people from other states who move here, especially from the East Coast, they're so shocked at how fast they can be evicted from a house or an apartment.
Right. And I think the California is one place we see a lot of people questioning the laws here as opposed to what they were over there.
Yeah. And some leases don't even really have a grace period on rent. So, they're used to 10-day, 5-day grace periods. And here it's like, nope, it was due on the 1st and you don't have a grace period. It's like, yeah, you can get served with a 5-day notice on the 6th. It's kind of a big deal. So read your lease agreements, tenants.
And the notices, have to be served legally too, which is
Yes.
physically handing it to somebody or certified mailing.
Yeah, and that takes a couple of days.
Yeah.
So it's a fast process.
5 days for mailing for each notice. So really a 5-day notice turns more into like a 10-day thereabouts before it's counted as received and past the time to take action from there.
Yeah. So in your experience as a property manager, like normally, do you give leeway to your tenants who pay rent, or do you just cancel the 10-day notice or 5-day notice?
A lot of it comes down to, is this a one-time occurrence? The main thing is, again, going back to fair housing, is we have to treat everyone legally. And so I have to be careful about how I handle things in relation to that as well. Because one tenant say, well, you gave, that person some leeway and not me. So within the lease itself, I already have built in 3 days of grace. So rent's not late till the 5th. So there's already some grace built into the lease to help them out. And then as far as everything else, legally, if they pay all the fees and everything, then, they're welcome to stay, or there's no issue at that point. A lot of also depend on my conversation with the landlord themselves and say, hey, they owe, $1,000. They've brought me, a $900. Do you want to accept it? And 9 times out of 10, owner's going to say, yeah, go ahead and take it, and then go from there.
Awesome. Anything to add from either of you? Andrew, Irene? Yeah, I thought you covered that pretty well. So let's talk about fun stuff in the news and these short-term rentals. We're seeing the super rise of Airbnb and just vacation rentals in general. How does that affect insurance and property management? And what can you do from an eviction standpoint for someone who's maybe holding over longer than their stay?
Well, short-term rentals is an extremely important conversation with your insurance agent, because the policy may exclude that depending on what happens. There are more insurance companies that are accommodating the needs of those landlords that have the short-term rental needs. So it's an extremely important conversation to have. Homeowners insurance policies generally, I should say, do not address short-term rental use on a property. And Airbnb offers a certain amount of coverage, which is primary coverage for the person that is using their property for Airbnb purposes. However, that coverage is designed to mainly protect the company, Airbnb. So it doesn't truly address the full needs of the property owner. So the property owner should have the right policy in place, depending on how often is it used is the property used as short-term rental. So how many months out of the year, how often? So that is a conversation to have that is extremely important. I also find out that the coverage through Airbnb excludes loss of rent. So if the short-term tenant that's staying there causes damage to the property and, it has to be repaired because it's not inhabitable, that loss of income is not covered under Airbnb. Among other things, punitive damage, any kind of liquor-related claim is also excluded. So definitely the right policy in place for short-term rentals is the way to go.
What I've seen in conversations in different classes I've gone to and talking about market activity, there's a few more hoops to jump through with Airbnb. The biggest thing, if an owner is considering doing an Airbnb, and I do basically strictly long-term unfurnished rental management. However, I have friends that do short-term rentals and am familiar with that model. The thing that an owner want to check is, number one, most homeowners associations, if it's in a homeowners association, more than likely they're not going to permit it.
Yep.
So as soon as you do it, you're probably going to get a letter from the HOA within a month. The other thing to be aware of is, obviously the insurance, and then things like rental taxes also change a little bit. I think they usually change it to lodging tax at that point, which is a higher tax rate. Depends on the city, and I think even within each city, there's different laws I think are being discussed or passed. I think residents in the last market update went to, there was some residents in some of the higher upscale neighborhoods like Paradise Valley or whatnot, or they're trying to pass things to make it a lot more difficult for those with that type of scenario, just because of different problems that have arisen. So it'll be interesting to see what happens. I would say if someone's considering that model, purchasing or having, just to make sure you look and see what area you're purchasing it in and what things may affect it in the long term.
Agreed.
Yeah, because those HOA fines can be pretty excessive for violations, and
they will get their money.
Yeah. We've been fortunate; we haven't had really any BR&B issues come up. So
that's good. Hasn't gotten that far yet.
I'd like to share a story. This happened to one of my clients. She owns a 10-unit apartment building. A tenant leased a unit on an annual term. And later she found out that tenant was listing the unit on Airbnb. So the tenant was making bank subletting that unit on Airbnb. That is why since then I recommend all of my landlord clients, Google your property address every now and then, see what comes up.
Yeah, that's pretty terrifying. Please, everyone do that.
Most leases will have a no subletting policy,
Absolutely.
Especially long-term ones. So there's definitely action that can be taken in
when
that
you realize
situation.
that's happening. Agreed. So let's wrap this up with one pro tip that you can give our listeners related to your industry. So let's start with Andrew. What is one pro tip that you can give to people who are thinking about residential rentals?
Well, let's see. I would say there are plenty of classes around. Take a class, familiarize yourself with what the laws are. Our office does it. City of Phoenix has seminars, and there are a lot of other ones out there.
Great tip.
I would say do your homework. Call different people. That kind of goes along with what Andy talked about, taking a class, and then ultimately look at all the numbers for your bottom line, because that's the biggest thing for every landlord, is to see if it makes sense profitability-wise.
Yep. Great tip.
For me, my recommendation is develop a strong relationship with your insurance agent. A good insurance broker can be a strong advocate for you and your property in case of a claim, and can be big help with the insurance when dealing with the insurance company. And a good insurance agent will look out for you in ways on how to create layers of protection, protect your assets.
Like umbrella policies. And a good agent can provide valuable advice as your needs change. Love it. So I think that covers everything. Thank you guys for being here. Please tell our listeners how they can reach you. Let's start with Andrew.
Website
and phone number, whatever works.
Yeah, website is www.drevictor.com, and office phone number 602-230-0088.
My website is www.bullseyeaz.com. Office number 480-907-9050. And email is nick@bullseyeaz.com.
Well, Independence Insurance, we're in North Phoenix on 32nd Street and Shea. And our website is www.indie, that's INDIE, insurance.com. Phone number is 480-656-1036, and email is info@indieinsurance.com.
Love it. So thank you, Irene Ploski, Nick Stratton, and Andrew Holl for being here and giving us the legitimate perspective. And thank you to our sponsor, AZ Credit Law Group, providing legal services to help people improve their credit. You can visit us online at azclg.com. And thank you to Phoenix Business Radio X. And as always, to you listening. And join us next time on January 2nd at 3 p.m. for our next episode in the world of debt, Zombie Debt. I'm Rochelle Poulton, legitimately yours, and I'll talk to you next time.